You can take Jennifer off now.
Ow. Okay, good. Remove edit name. Ouch.
You could be cruel.
Okay. Cruel.
Cruel.
I don't have a picture of her.
You don't know what you
Edit
look.
avatar. It's going back to regular.
Okay. All right. I'm waiting for. Oh, let me put. Oh, hey guys. How you guys doing? Thank you for all those who just who supported in getting me to be here instead of thank you Trissy. Thank you Tamiria. Thank you Vivian. Thank you. Who else? Let me see who else is this. Let's see. Thank you Tamiria. Thank you Vivian. Thank you Trissy. Thank you Kimberly Black and thank you Pretty Brown Eyes. Thank you guys. I appreciate y'all. Thank you so much. All right, let's get going. Let's get going. I'm waiting for Pretty Brown Eyes to come on in. Um is she coming in right now?
I don't think so.
No, she
She's
said she's coming later. Just me and you then, right?
yeah, I guess.
All right, we can do that.
All right. Ooh.
Yeah, Trissy, you made it happen. Thank you for making it happen for me. Uh,
So you just want me to start from line
no, we're
8?
gonna start from the beginning. We're gonna start from the beginning because
Okay.
they weren't here. They were not here. Hold on a second, guys. All right, let me see. All right, guys, this is a grand jury superseding indictment that occurred on I'm not May, on February 13th, 2020, on Thursday at 10 a.m. It's a superseding indictment, and who was here was Angela Cruel, and so we're going to go ahead with the presentation by Angela Cruel and what actually happened. All right, guys. Are you guys ready? Are you guys ready? You guys
Let
ready?
me switch my phone to the desktop version. So it's gonna take me off and put me back on. Hold on one second.
Okay. All right. Just take your time. Let me say hi to folks in the chat first. Hey T girl. Hey Bree. Hey Nakenya. Hey Black Beauty. Hey Kimber. Caribbean for Life Carib. Hey Too Cute. Hey, Trissy. Hey, Kimberly Black. All right, let's see. You guys are ready. Okay. All right. Thank you guys. And this is going to be for you guys to see what went on. And guys, remember when we were talking about how dirty they were and how stuff they were doing? Well, we're gonna read the super indicted and this one is the one that you guys please pay detailed attention to this, okay? All right, you ready, my girl? Let's get this rolling. And I'm going to be the grand juror. I'm going to be the foreman. We're going to switch around who's who, okay? But she's Miss Cruel. All right, this is the superseding indictment for February 13th, 2020. The grand jury having to reconvene at 1:20 p.m. on the 13th of February, pursuant to adjournment, met in closed session, and the following proceeding were had herein. All right, Miss Cruel, go ahead on. Unmute yourself, Miss Cruel. You're probably using the Miss Cruel. She probably attached with
My
the other
bad. I
one.
was reading. Okay.
Okay.
I'm sorry. Good afternoon, everybody. I am Angel Cruel, Assistant United States Attorney. This is 19 GJ 291. The target is Robert Sylvester Kelly and Associates. So I'm here today to present the superseding indictment, the long-awaited superseding indictment. So what I'm going to do today is go over the changes that are in the indictment. Yes?
We have a new grand jury.
Oh, yes. Hello.
Ronnie?
Hello, Ronnie. So this is a very long investigation. The your jurors here have heard a lot of information. I'm going to summarize some of the information. However, it is up to you and the rest of the jurors to decide whether or not you feel like you've heard enough evidence to vote on the case. I will leave that up to you. It's not up to me. It's up to you. If you have questions about the evidence, I'm happy to answer the questions as long as you have a quorum. Would that work?
We do.
Okay. If she decides she has not heard enough evidence to vote, I do have some questions relating to potential conflicts, and I will ask you a few of those questions right now to see if you have any conflict with hearing the case. As you probably heard, I just said the investigation involves Robert Sylvester Kelly. He is a famous musician, also goes by the stage name of R. Kelly. Have you ever been to an R. Kelly concert?
No.
Have you or do you know anybody who has been involved with R. Kelly?
No.
Do you know Mr. Kelly?
No.
Have you watched the programming Surviving R. Kelly?
No.
Have you watched the program An Interview that was conducted, I believe, in March of 2019 that was with Gayle King? I mean,
Mm-mm. Mm-mm. Read it
um,
as you see it.
huh?
Read it as you see it.
Okay. Okay. Um, have you watched the program? An interview that was conducted, I believe, it was in March of 2019. That was with Gail Kelly. I mean, Gail King. Sorry, Gail Kelly.
No.
Gail King did an interview with Mr. Kelly. Did you watch any portion of that?
Shaking my head.
Okay. I don't know if you're getting her answers. She's shaking her head.
No.
Um, so the court reporter says, I do hear her very slightly.
Sorry, I'll speak up.
Okay. Is there anything related to Mr. Kelly that you believe would make you not be a fair and impartial grand juror in this case?
No.
Okay, then we can proceed. Okay, so before I get into the proposed superseding indictment and the changes in the evidence that you've heard related to those changes, I wanted to just talk a little bit about scheduling going forward. I know that I have mentioned in the past that after we returned the superseding indictment, that there is potential that you wouldn't see me anymore and we would be done with the investigation. And I want you to know that is not true anymore because, as you know, this investigation continues to develop continues to develop, and especially because it's an investigation that covers a long time frame going back to 2 decades, maybe more. So one of the reasons why you haven't seen me in the last couple of weeks when I thought I was going to be back doing the superseding indictment is because we have been receiving more information, and I do believe that I will be back here on March 5th with a new victim. I have I traveled recently with the agents in the case to go visit with a new victim. We have interviewed her and we're in the process of making travel arrangements to bring her here to testify before you. We kind of thought about whether or not we wanted to wait on the superseding indictment until she had time to come so we wouldn't have to do it twice. But ultimately, we decided we wanted to go forward with what we have now. And because, as you know, with scheduling witnesses, sometimes you never know if that's going to happen on the date you anticipate. So it might be pushed back beyond March 5th. So we just decided to go ahead and with the superseding indictment today and see if we'll have to do another one later. But I do expect all signs are pointing towards like she is cooperating and she will be coming to testify. We believe on March 5th. Yes.
So you're not allowed to just let this one lay and have a totally new indictment. It always has to be superseding.
No, if we wanted to, we could do it in a separate case. I won't get into the weeds too much on that, but my expectation would be if we did it that way, the two cases would get merged anyway.
Okay.
It would probably be a motion to combine the two, and so procedurally, it just would be a lot of hoops and jumps through. I think to do it the other way that you're suggesting, if it's all going to be together anyway.
Okay.
But that is one way we could do it. So in addition, oh,
Sorry. Is there a limit to superseding indictments?
no.
Okay, just wondering about that.
Okay. I don't know. I mean, what is normal is it's typical to supersede. How many really depends on the judge that has the case and what your trial date is. And at some point there is a deadline where the case is going forward and you can't supersede anymore. But then in that case, we could always bring a different indictment. So then yes.
Sorry.
Go ahead.
So, superseding indictment may be in this case. Do they add counts or do they revise existing counts or a little of both?
And I'm going to get very specific in the weeds on that in just a few minutes. And then I'll explain what the changes are. And the short version is yes, we're adding a new count, but we're adding some other things too. Do you have a question?
Has the missing porn tape ever showed up? There was like a bunch.
Right. My mind is thinking which one, but I believe you're talking about the video 4, which is what we named it in the indictment, which was the one that you heard testimony about relating to. It was Mr. Kelly and two individuals, minor one, Rashonda Lanfair, and minor two, who is in this indictment. The previous indictment, as her name was Lisa Van Allen, it was the three of them. And you heard testimony about the existence of that. So, no, our evidence has not changed on that. The evidence is still the same, meaning that the video has not surfaced, although we have. I'm trying to remember if it was Miss Lanford Fairs testified about that encounter. Miss Van Ellen testified about that. Mr. Keith Muro testified about that video, and Mr. Charles Freeman just testified about that video. So we have 4 witnesses who have testified about that video, even though we don't have it. I mean, the reason why we don't have it is that you heard testimony about how Mr. Keith Morrell returned the tape to Mr. Kelly's associates and was polygraphed and paid 100,000 in order to as part of that. So the reason we don't have that tape is because it was returned to Mr. Kelly.
Okay.
Okay.
She said, I don't understand this part. Who is explaining superseding? Okay. She's Miss Cruel. I am the grand jury. So anytime you hear my voice, it's the grand jury. If you hear her voice, it's Miss
It's the
Cruel,
government.
the
I'm the government.
government. Yeah.
Okay. So the other development that we've been working on, and you will likely hear additional evidence on, you may recall that you heard testimony about individual by the name of Jack Palladino. He was a private investigator that was hired by Mr. Kelly to investigate the thefts on those videos and assisted Mr. Kelly in getting those videos back. And you may remember that we showed you, and I'm actually going to show you this in a few minutes when we talk about the changes to the indictment. There was a contract between Jack Palladino on behalf of Mr. Kelly and Charles Freeman for the recovery of one of those sex tapes. Anyway, we had issued a grand jury subpoena to Mr. Palladino for his file, his records relating to all of this, and there was a lot of back and forth. I think I told you one of the reasons was because, in addition to being a private investigator, Mr. Palladino is an attorney. And so there is special rules when you subpoena an attorney. We worked through all the special rules, but it took some time. And so we finally got the documents from Mr. Palladino's attorney. So we have been going through those documents, and there are leads to follow up on other people that we're interviewing based on those documents. And so I expect that you will have some testimony relating to Mr. Palladino in the future. So those are the two things that have been going on since I saw you last. But for now, I do believe we are ready to go forward with the superseding indictment
Seating.
and superseding indictment. And I'll start with that unless you have any questions. You can always interrupt me and ask me any additional questions if you have any. So this is the very same slide that I presented to you last time when we did the first indictment. And I wanted to show it to you again because the type and number of charges are exactly the same. And you'll see why in a minute. But there are still 4 counts of sexual exploitation of a child. There is still that count of conspiracy to obstruct justice, which is count 5. There is still count 6, which is the conspiracy to receive child pornography. Same counts 7 and 8, receiving child pornography, and there are still 5 counts of coercion and enticement of a minor to engage in sexual activity. So those counts stay the same, although there's some changes within the counts that I will go over with you. Also, what's the same? What's the same? This is what I had showed you last time. Same 3 defendants and their names and the same counts. So all of that is the same.
Document displayed on the monitor screen for the grand jury.
So what's different? So the first difference I will show you. The first difference has to do with some additional records. Here we go. So additional bank records that we received relating to Milton June Brown regarding how long he worked for Mr. Kelly. As you know, you saw some evidence and some testimony from an IRS agent. I'm trying to remember the exact date, but he testified recently regarding bank records that he subpoenaed, and based off of the bank records that he subpoenaed, we decided to update the time frame regarding when Mr. Brown worked for Mr. Kelly and his associates. And so I'm going to show you this new paragraph or revised paragraph, which has to do with count 5 of the indictment. So here's the page of count 5. It's paragraph 1C and very bottom. So this has been revised. This is new in the indictment and in the time frame. It now says at least approximately 1997 to at least approximately February 2019, whereas before it ended in June of 2018. Now it says February of 2019. That's a pretty simple change. Next, as I've mentioned before, we have removed Lisa Van Allen from the indictment as minor 2. She is now referred to as individual D throughout the indictment. And the reason for that, you may remember you heard testimony. Again, this was from the same witness. IRS agent Scherer did some investigating and determined that at the time that Miss Van Allen met Mr. Kelly, she had just turned 18 when she had thought she was 17 at the time. But we were able to determine that she had just turned 18. I like how they said just turned. If
You
you
didn't.
recall her testimony, huh?
She didn't just turn 18 because it was in August and her birthday's in June.
Mm,
Just mean a couple of days ago.
yeah.
And let me tell you something. When you turn 18, that's a memento birthday, okay? Who don't remember they just turned 18?
She knew how old she was. She knew how old she was.
Go ahead, I'm sorry.
If you recall, her testimony was that she met him on a video shoot for the video Home Alone, which happened in Georgia, where she lived, and obviously that was a long time ago. She had estimated that it happened in 1997 or 1998. She couldn't be sure exactly when. The agent testified that he did some digging, that he interviewed various people who were associated with the music video. He, in fact, interviewed the owner of the home where the music video was shot, and he had records of the dates that the home was rented for that video shoot. And he also spoke with the individuals who filmed the video. Based on that additional information, we were able to determine that the video shoot happened just after Lisa Van Allen turned 18. And because of that, under the law, she wasn't a minor. So we were removing that count of the indictment. She still remains in the indictment. She is very important still to the indictment with respect to the obstruction of justice allegations
I
and
got a
the
question for you. Hold on. So in the video with Surviving R. Kelly, didn't she still say she was 17 when she met him?
she definitely did.
Okay.
And what date is this let out? This is the
This is 2020.
mm,
It's February 13th, 2020.
okay. Well, that means Surviving R. Kelly was out first. So she can still keep going with her lie, even though
So
she
she
knows the
lied.
lie.
She lied. She lied.
Hmm. Okay. She still remains in the indictment. She is very important still to the indictment, which with respect to the obstruction of justice allegation and the indictment relating to the videotapes, because as you recall, she testified that she took one of the videotapes that had herself on it and then later on returned that videotape to Mr. Kelly in exchange for money. So is still in the indictment, identified as individual D with respect to that, but she is no longer listed as minor two. And I want to show you the new indictment specifically. Count 5, paragraph 1D. 1D lists the minor, and as you can see there, D is minor number 1, and then E is minor number 3. So it jumps up from minor 1 to minor 3. That's because we removed minor 2. That's the change. I'll get it. I'll get to it in a little bit later. But if you look down to H, we had added minor 6. There was no minor 6 before. Before it was just 1, 2, 3, 4, and 5. But we removed 2, which was Lisa Van Allen, and we've added 6, which is Ashley Waller, which I'll get to in a minute. So that's that change relating to Lisa Van Allen. So next, as I mentioned, Ashley Waller related to minor 6. The last time I was here, we read through Miss Waller's grand jury testimony. If you recall, she was a close friend of minor number 1, Rashana Landfair, and she was introduced to Mr. Kelly by Rashana, and Mrs. Waller described numerous sexual encounters with Mr. Kelly before she turned the age of 18. One of them in particular, the very first one, happened on a trip to New York City that she described. An encounter happened in New York City at a hotel there, and then she described many other encounters with Mr. Kelly, all happening when she was under 18. And so because of that, we are adding her to the indictment. So that is a new count 13, and I will show it to you. So this is count 13 of the indictment. It says beginning from approximately 1997 and continuing to approximately December of 2000 at the Chicago, um, in the Northern District of Illinois, Eastern Division, Robert Sylvester Kelly, also known as R. Kelly, the defendant herein, using the mail or any facility and means of interstate and foreign commerce, did knowingly persuade, induce, entice, and coerce any individual, namely minor six, who had not attained the age of 18 years to engage in sexual activity for which any person can be charged with a criminal offense, namely aggravated criminal sexual abuse in violation of Title 720 Illinois Complied Statutes, Section 51216D, in violation of Title 18 United States Code Section 2422B. That time frame at the top, approximately 1997 through December 2000, approximately 1997 when the first sexual encounter happened, and December 2000 is when she turned 18. We decided not to include the specific date of her birthday in the indictment of when exactly she turned 18. One way we could have done this is had that end date be very specific to December. Say I forget exactly when her birthday is, but for example, December 1st, 2000, which may have been like the last day that she was 17, the next day she turned 18. We decided to not to be that specific about her birthday because we didn't want to basically. Oh, excuse me, 1 second. A child has entered into the courtroom. Okay, go drink the other one downstairs on the table. Go ahead. That yours? Yeah, that one's mine. There's another one downstairs. Okay.
Sorry, guys, I had to mute her. I had to mute her for a minute so she could come back and be able to continue her reading. How you
I'm back.
guys like this so far? Hit the thumbs up.
I'm back. I just had to send them out.
Okay.
Um,
Number one.
specific. Okay. Specific about her birthday because we didn't want to basically out her to the public. If we very specific if we're very specific about a person's birthday, people could look her up and identify her through her birthday in the indictment. And that we're very aware of the specifics that we put into the public documents like this. That's why we're calling her minor number 6 and not including her real name. We want to make sure that she is protected because she was a minor at the time that this crime happened. Do you want me to skip over names or are you good with
We already started reading the name.
this? Okay.
Case is over with.
I'm just saying. Okay. You also heard evidence that her interactions with Mr.
Ma'am,
Kelly.
hold on. It's in the public records. If they
Okay.
didn't want us to see it, they would have just kept it sealed.
Yep. I just wanted to make sure. I'm like, oh shoot, because I learned a
Yes.
new name, and the Lord knows I'm about to go snooping. But anyway,
No, you're not.
okay, I'm not. Um, you also heard evidence that her interactions with Mr. Kelly went beyond her 18th birthday, and she continued to have relationships with him and suffered abuse by him beyond 18th birthday. But for purposes of this charge, we're only focusing on the conduct that happened to her when she was under 18. So that is the new count relating to Mrs. Waller.
I
So
have a question. Oh,
go.
we have a question.
Oh, okay. So, oh yes. Um,
Did
go.
we already have account 13
Yes, we did.
related to Tabitha?
We did. And so what happened was because we removed minor number 2, let me put it back up here.
Count 10.
Yes, she was count 10. So we removed old count 10.
Okay, so you took count 10 out?
Right.
Okay.
We took we took count 10 out because that was Lisa Van Allen. And so all of the numbers changed after that.
Okay, that's what I was wondering.
Okay. Exactly. Good question though. You keep good notes. Okay. So number 4, the next change relates to a new allegation in count 5 of the indictment. Specifically, that new allegation is at paragraph 6D of the count 5. So I'm going to pull that out right now. So paragraph 6D, I'll read it. It says, on or about April 17th, 2007, Kelly and McDavid caused one of Kelly's businesses, Base Production Ltd., to issue a check in the amount of $200,000 to Brown, who cashed the check that same day, which Kelly, McDavid, and Brown intended to use to pay individual C and individual D for their efforts to return to Kelly videotapes that they knew depicted Kelly engaged in sexual contact and sexual acts with minors 1 and individual D. And there, to be clear, individual C is Keith Morrell and individual D is Lisa Van Allen. Now you heard evidence of this check, and I want to show it to you just to remind you. So on November 21st, 2019, Special Agent Jason Schaefer from the IRS testified, and as an exhibit to his testimony was this $200,000 check that we're talking about here specifically. It's Grand Jury Exhibit 115. Um, so here's the
Document
check. Oh,
document displayed on the monitor screen for the grand jurors.
so here's the check. It's in the amount of 200,000 from Base Productions care of Winkler and McDavid Ltd. It's signed an initial DM for Daryl McDavid for 200,000 to Milton Brown, and the date is April 17th, 2007. And there on the back, it was cashed on the same day. You can see the date there. It was cashed on April 17th, 2007. And you heard the testimony that day from Agent Scherer that that was the date, April 17th, 2007, is the same date that Mr. Morrell and Mrs. Lisa Van Allen came to Chicago to return the sex tape in exchange for money and took a polygraph examination. And their agreement was that they were expected to receive 200,000, 100 for Lisa, 100 for Keith, with the remaining 50 to be paid after Mr. Kelly's state court trial was over. That's not adding up.
It's not.
200, yeah, it's not even adding up.
It does make sense.
That didn't happen that day. You heard testimony because the tape that they returned that day was not the full length tape. Remember, they only returned a little snippet of the tape. And because they didn't return the further length tape, and Mr. Morrell failed his polygraph examination when he was asked if there were additional copies of the tape, they were paid a full amount that weren't paid a full amount that day. Instead, they were each paid 20 with instructions to go back and get the full tape and come back to Chicago, and they will get the rest of their money. So, this new paragraph in the indictment related to that check, that cashing of the check, which shows that all that same day, with all of that was happening with Keith and Lisa in Chicago, that Kelly and Mr. McDavid had this check written to Milton Brown, who then took the check to the bank, cashed it, and walked out of the bank with 200,000 in cash. So there is a couple new allegations related to the Mr. McDavid in the indictment. First, in count 5, paragraph 6G, I'll read that for you. It says, in approximately 2014 and 2015, Kelly paid McDavid to ensure that McDavid would continue to conceal and cover up evidence, including but not limited to video 2, video 3, video 4, relating to Kelly's sexual contact with sexual acts with minors. Now, let me put that back up there. You heard lots of evidence on this relating to Mr. McDavid's lawsuit against Mr. Kelly and the payments relating to that lawsuit. And the argument is that those payments were to keep Mr. McDavid quiet about everything that he knew about Mr. Kelly's acts with minors. And you saw the evidence there of what was in the lawsuit, along with Mr. McDavid's affidavit stating some of the things that he knew about Mr. Kelly's acts with minors, in particular, minor one, Rashonda Landfair. So that was what that paragraph is about. And then the other paragraph relating to this is paragraph 8D of that same count. This is a paragraph that was already in the indictment already, but it's just revised slightly. So I'll read it to you. It says in approximately 2014 and 2015, McDavid received payment from Mr. Kelly relating to the services he provided to conceal and cover up evidence, including, but not limited to video 2, video 3, and video 4, and to continue to conceal and cover up such evidence of Kelly's sexual contact and sexual acts with minors that he provided to protect Kelly's image, reputation, and assets in the face of actual or potential criminal and civil actions by individuals who were victims of sexual misconduct by Kelly, including services that McDavid provided to falsify and create a false entry into a record, document, intangible object. So, what I just read is along the same lines of what I just explained to you. Some of the language is taken directly from Mr. McDavid's lawsuit against Mr. Kelly, specifically that part in the middle where it says to protect Kelly's image, reputation, and assets in the face of actual and potential criminal and civil actions. That language is taken directly from his lawsuit against Mr. Kelly about his role, what his role was there. So that's the new language in paragraph 8D.
And what would be the false entry?
So the false entry, I had the same question. So good juror. Um, so the false entry services that he provided to falsify that very last language there. So there is allegations here in the indictment relating to Mr. McDavid instructing people to lie. One being, if you recall, Miss Landfair's father. He instructed Mr. Gregory Landfair, I was blanking at the first name, to lie in the state grand juror, which resulted in a false grand jury transcript in the state court.
Okay.
That's one. The other example that we have relates to Miss Lisa Van Allen. If you recall, there is an allegation in here. I can pull if you need to be refreshed. On it, when she was taking one of her polygraph examinations, she was made to meet with individuals, lawyers, where she was told to lie about her relationship with Mr. Kelly and Rashonda Landfair, and that Miss Landfair was not a minor at the time. And as a result of that interview, a report of that interview was created, and that was a false record, a false report. I'm going to find that for you so I can refer to it, and so that the record is clear. Here it is, paragraph 7E of the indictment. And this was part of the prior indictment. This part hasn't changed. So 7E there says, on or about July 26, 2007, Kelly and McDavid directed individual D, who is Lisa, to falsely deny that individual D and Kelly engaged in sexual acts together with minor one, when Kelly and McDavid knew that Kelly had engaged in sexual acts together with minor one and individual D. And as Kelly and McDavid intended, a false record, document, and tangible objects was prepared based upon individual D's false statements. So that's one of the false statements we're talking about. Okay. So now we're going to move on to Mr. Freeman. We're adding 2 overt acts to our indictment, and this is in count 5. Everything we talked about has been related to count 5, which is the obstruction of justice conspiracy. Let me read the opening paragraph of the overt acts section. It says, in furtherance of the conspiracy and to accomplish the objective of the conspiracy, defendants committed one or more overt acts in the Northern District of Illinois, Eastern Division, and elsewhere, which overt acts included, but were not limited to the following. And so this first paragraph here is paragraph A, is a brand new paragraph, a brand new overt act that we added. It says, on or about August 21st, 2001, individual A, acting as an agent for Kelly and McDavid, entered into a contract with individual D to recover and return videotapes that depicted Kelly engaged in sexual contact and sexual acts with minors in exchange for 100,000 plus no more than 40,000 in expenses. The contract required in video B deliverer the tapes to individual A by Thursday, August 23rd, 2001, in order to receive payment. Now we've added that paragraph based off of this contract that we received, which is part of the testimony on September 5th, 2019. And it's part of the Exhibit 111, the last page of the Exhibit 111. You will recall this is the contract that we're referring to. Individual A in the paragraph I just read is Jack Palladino, that you have seen in the first paragraph, and it's contract between Mr. Palladino on behalf of his client, who was Mr. Kelly, and the agreement is with Charles Chuck Freeman relating to the recovery of a video. And at the bottom there, you see it's dated August 21st, 2001. There's also a fax line at the top that has that same date, August 21st, 2001. So that is what our new overt act in paragraph 11 refers to.
Question.
Yes?
Is the overt act the entering into the agreement, or is it the delivering of the tapes?
It's the entering into the agreement. However, the delivering of the tapes could also be a separate overt act because they are both acts that were committed to accomplish the objectives of the conspiracy. And so there is no limit or there is no requirement to list all of the overt acts. The indictment is just required to put the defendant on notice of what the crime is and what the evidence will be. And so you choose examples of what the overt acts are. You don't have to list all of them.
But entering into an agreement is a type of overt act?
Yes, it is. Yes. And the other overt act that we added is paragraph 11E, which relates to the payments, another payment. There were several payments that you heard about to Mr. Freeman relating to his activities for collecting the tapes. Ooh. Excuse me. We picked one of them. This one relates to a wire payment made from Bass Productions to Individual B. That's Charles Freeman. Individual B to settle a lawsuit that Individual B had filed for payment for recovering and returning videotapes. And I just wanted to refer you back to Mr. Freeman's testimony about those lawsuits because I know it's been a while since you heard about that. This is the same exhibit I was just reading from. It's 111. This is Mr. Freeman's affidavit, paragraph 32 at the top. And in 2002 and 2009, I filed 2 lawsuits against Kelly, one of which was also filed against Mr. McDavid because I believe I was not paid what I was promised, and both times Kelly and McDavid paid me additional money, and I dismissed both of my lawsuits, which, as you can see, according to the contract, he was promised 100,000 plus an additional 40,000. So now we're going to talk about some of the time frames that have changed in the indictment. We already talked about one of which was the time frame that Mr. Brown worked for Mr. Kelly. Specifically, we changed some of the time frames in counts 7 through 13. First, in counts 7 and 8, let me put those up on the screen for you.
Document displayed on the monitor screen for the grand jurors.
In count 7, the time frame now says in or around August 2001, and I want to get what it used to say before what it was much broader. It said in or around 2001 and in 2002. It didn't have a month at all. It just had those 2 years. We've narrowed it specifically down to August 2001, and that's primarily based on the contract we just looked at. That was from August 2001, and so that's why we changed that time frame. I don't know if you remember, but we didn't have that contract last time when we did the original indictment. That contract was discovered after the original indictment. So this is count 8. And looking at the time frame now, it says from on or about April 17th to on or about April 20th. The old indictment had 2 months. It said March or April 2007. Now it's limited to I'm sorry, it's limited to April 17th through April 20th. So it was just a few days time frame. We were also able to narrow that down based on the polygraph records that shows that Mr. Morrell and Miss Lisa Van Allen were here in Chicago returning the tapes. So we have the specific dates now. Next. So I'll talk about these. I'm sorry, you're echoing or something.
Nope,
Next.
that's you. Not
I'm
me.
echoing?
No, 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 no. You hear it on your side. I don't hear it over here.
Okay. Next, so I'll talk about these as a group, counts 9 through 13. We decided to change the time frame for these, and I'll give you one example. I'll put up count 9 as an example. So count 9 relates to minor 1, and that was Rashonda Lamfair. Before, the time frame was limited to 1999, in or around 1999. And back then, we chose 1999 because we knew that one of the videos was filmed in 1999. So we used that as an example. But as you recall, the testimony of these victims was, in particular, I will use Miss Lamfair as an example. She was sexually abused by Mr. Kelly hundreds of times before she turned the age of 18, not just once. So we can call that a continuing offense. It's a course of conduct where the crime is committed over and over and over again for a period of years in particular, with it relating to Miss Lamfair. So now the language is approximately 1997 and continuing to approximately September 2001. She turned 18 in September of 2001. She testified that during that time frame, she was sexually abused by Mr. Kelly hundreds of times. So instead of having 100 to 200 separate charges of this crime, which we could do under the law, that's something that legally we could do. It's just not feasible to do it that way. There's also a concept under the law that's called a continuing offense or a course of conduct. And so that's what this is. That he repeatedly abused her during the time frame, and we decided to include the entire time frame in the charge so that all of that evidence can be admitted at trial as part of that crime. We ran the risk that if we just limit it to in or around 1999, that there would be a motion to exclude the evidence. That did not happen in 1999, and so we didn't want to run that risk. And so we changed the language so that it would include the entire time frame so that all the evidence could be admitted during the time frame until she turned 18. Does that make sense? Okay. And so what we did is we changed that for all of the victims for this type of crime. We expanded the time frame to include when the abuse began, to the month that they turned 18. And so I can just quickly go through that. This is the one example that didn't change because count 10 relates to a victim by the name of Tanisha Crowther. And she had only 2 encounters with Mr. Kelly, and both of those encounters happened in the summer of 1996. And so we didn't have to change the date and time frame for her because her encounters with him were pretty narrow anyway. And so we kept hers the same. But for everyone else, we did change the time frame. Count 11, as you see, count 11 relates to the victim Tracy Sampson. She was minor 4. And so before, we didn't have to change hers either. We had hers correct the first time. So the time frame is 99 to 2000, August 1st, 2000. And it still says 99 to August 2000. We decided to take out that's what we changed. Before it said August 1st, 2000, and now we've changed it to just August 2000 because that was her birthday. That was her last day of turning before she turned 18. And we didn't want to have her birthday like that.
I have a question.
Yes,
I don't mean this is in a disrespectful way or anything,
sure.
but why don't you first brought us evidence? You showed us the marriage license with him and Aaliyah.
I thought that was ruled out. Okay, yes.
So I was wondering why she wouldn't be part of this if he married her when she was a minor and abused her. Oh shoot, y'all.
That's
You
how
see
they
how
got this
dirty, you
indictment.
see how they dirty they are?
That's how they got this indictment.
Oh shoot.
That's a really good question. No, that's a really good question. This statue, and I can put it up here. This is something that the slide I showed you last time, this is the statue that all of these charges are. It's enticement of a minor, and these are the elements to prove I went through with you last time. This
That's why
statue
they
was
moved it to New York.
mm,
Okay, sorry, y'all.
this
They moved it
statue
to
was enacted by Congress in 1996. The marriage to Aaliyah happened in 1994. And so, because this statute was not in existence in 1994, we can't bring a charge related to Aaliyah for this particular statute. Then why
So
did you
that's
present it for
why
this?
they bought the bribery instead of, oh my god, y'all.
Hmm.
Okay, sorry.
The other charges, we do not have charges that were, let me take that back. We could have charged related to the pre 1996 for a different charge. The creation of child pornography. The statute was created long before 1996. So if we had a sex tape with Aaliyah, we could charge it because that was not enacted in 1996. Unfortunately, this particular statute wouldn't apply for Aaliyah, but that's a good question. So I was about, I believe, to show you counts 12, which relates to victim Tabitha Blaylock, which was minor number 5. So before the charge relating to minor number 5, the time frame was in or around 1997 and 1998. Now we expanded it to October of 2001, which is when she turned 18. And then count number 13 is the new victim, Ashley Waller. Okay, so the next change to the indictment is to the forfeiture allegation. And this is the forfeiture allegation at the very end. I'll read it to you. So, upon conviction of an offense in a violation of Title 18 United States Code Section 2251 and 2252 as set forth in the superseding indictment, is defendants. I won't read you the names. shall forfeit to the United States. This is an important part. Any matter which contains a visual depiction described in Title 18 United States Code Section 2252A, that's child pornography. So if they have any child pornography, it's got to be forfeited to the United States, and then any property constituting the traceable to gross profits and other proceeds obtained from such offense in any property. Here we go is the important language. Used and intended to be used to commit or promote the commission of such offense in any property traceable to such property as provided by that statute. I'm not sure if you guys caught that because I'm reading it and I didn't catch it. Did you understand me?
They're talking about the forfeitures and saying that with the child pornography, if there was profit from the sale of the you know.
Okay. As long as y'all got it.
Yeah.
Okay. And so paragraph 2 relates to Mr. Kelly only because he is the only one charged in 2422 counts. Those are the enticement counts we're just talking about. The one for each victim and has similar language there at the very end. It applies to the property used or intended to be used to commit or facilitate the commission of the offense in any property, real or personal, that constitutes or derives from proceeds traceable to any such offense. So there are two categories of things that the government is seeking to forfeit under this forfeiture allegation. The first one, as you see at the bottom, there is a personal money judgment in the amount of at least,
Whoa. Whoa.
what is this? 1,554,778 dollars, and that is an estimated amount. That is a minimum amount because it says at least approximately. That constitutes the money. The evidence that you've heard that has been paid out to various individuals to collect those sex tapes or to keep them quiet, those hush money payments. So all of the money that went to Lisa Van Allen and went to Keith Morrell and went to Charles Freeman, that went to Rashonda Landfair and her father. All of those payments, and Daryl McDavid to keep him quiet as a result of his lawsuit, we took all of that money and added it together and came up with the minimum amount of that 1.5 million.
So that's
So
what they're looking for her.
Huh?
For that, they're looking for that amount for her.
Mm.
Roshana. Did you read that?
I just read it, but I didn't get that. Ouch.
Read it again.
Okay.
All the money.
Let me go back. So all the money that went to Lisa Van Allen, that went to Keith Morrell, that went to Charles Freeman, that went to Rashonda Landfair and her father, all of those payments. And the Daryl McDavid to keep him quiet as a result of his lawsuit. We took all of that money and added it together and came up with a minimum amount of that 1.5 million. So we're seeking to forfeit that money because that money was used to commit the offense. Does that make sense?
You get it? That's how much I guess she's gonna end up getting.
1.5 million.
Wow. Okay, go ahead.
Okay. And then the other category of what we're seeking to forfeit is at the top there. All right. Title and interest in stock and other ownership interests in Bass Productions Ltd. and Winkler and McDavid Ltd. in whatever form held by the defendant. And this is what I went over with you a few weeks ago with all of the evidence showing the involvement of those two companies relating to how those companies were used to make those payments, whether they be checks or, as an example, that 200,000 check that I just showed you. that was from an account from Bass Productions. It was care of Winkler and McDavid. So that's one example of those businesses being used to commit crimes. Now you may be wondering, I thought that there was a third company that Angel told me about. So, yes, there is. There's a third company, RSK Enterprises. We haven't forgotten about RSK Enterprises. We have a little bit more work to do with RSK Enterprises, and we may be adding RSK Enterprises to the indictment when we come back because, like I said, they're not done. You're not done with me. Hmm. I'm bringing another victim in, so we may be superseding again, and at that time, we may be adding RSK Enterprises. But for now, the two that we're focusing on are Bass Productions and Winkler and McDavid. All right, almost done with the changes here.
Question.
Oh yes,
Regarding the forfeiture allegation for the video,
yes,
I can't imagine someone would just hand them over.
right.
So does the government then go in with a search warrant looking for these because there is a reasonable belief that they are in possession of it?
So certainly, if we believe we have a probable cause that a video exists and that we have probable cause to believe that it's being held at a particular location, we would do that with the search warrant. The problem is not that the video exists, but the location where it's being held at. We have to have probable cause for both things,
Uh-huh.
not just that it exists, but the probable cause that it will be found at a particular location. And so, certainly, the investigation that's number one on their list is to try to find these tapes, but it's pinpointing where they're being stored, where they're being held, which is proving to be a little bit troublesome, but we don't give up. One thing about the federal government is you might not hear from us for a while, but we never go away.
Wow.
Never.
I got a question
Yes.
about the 1.5 million was paid out. Does the government have to get it from the source that was paid out to?
No. So, what happens here is the money. That's a very interesting question. The money here, and I'll put up the language again. Where did it go?
Document display the monitor screen for the grand juror.
Because it was used and intended to be used to commit and to promote the commission of the offense, Mr. Kelly, Mr. McDavid, and Mr. Brown used this money as sort of a facilitating property to facilitate the commission of the offense. So that could be anything really. So for a moment, maybe, if you want to think about it not being cash, maybe it could be a vehicle or it could be another piece of property that maybe was used to facilitate the offense. It doesn't really matter who owns the property. It's the property that was used that is forfeitable. Cash is uh fungible. Fungible? I think it was supposed to be tangible, right? This cash and this cash, you can exchange it. It's not something unique like a property or a vehicle. So it doesn't really matter where it's getting it from. We're getting it from. Here, because these defendants use that money, even if it's no longer in their possession, because they gave it to somebody else, they're still responsible to forfeit that money. So even if it was paid out, they can say, "Hey, I don't have that money anymore." Well, you still use that money to commit the crime, and so you're still on the hook for that money. Does that make sense?
Yes.
Yes.
I'm just wondering how broad could that be when you say forfeit, right to property? I'm thinking the Olympia Field House and the track studio, the George Street. Could you go to all of that?
I like the way you think. If Mr. Kelly still owns those items, then yes, those definitely were facilitating properties, and the properties that were used to commit the crime, because those were locations where the crime was committed. And so he doesn't own those properties anymore. None of those. And so there are innocent owners there now. And so people who had nothing to do with any of this.
But if he sold those property, what he got money for the sale of those property, could you go after, find out what he sold them for and get some of that money as well? Damn.
Okay, this juror is with the
This juror
movie.
really want to go after him. Lord have mercy.
Right. God. Yes, and there are two different concepts in the law on ways you can get money. One is through forfeiture, and the other is restitution. Mm.
Mm, mm.
And forfeiture is something that's in the indictment that we have to notify if it's some property, identified property. And the defendant has a right to get notice of that in the indictment that this is something we're seeking to forfeit. Aside from that, though, restitution is a concept that after someone is found guilty, that the victim have a right to be made whole to whatever damages that they have suffered. And so, what we're talking about, money that he has, is something that I'm
Hold on,
sorry.
she's got a call, y'all. Just hold on a second. You guys liking this so far? Can y'all hit the like button, please? Could y'all hit the like button?
I'm back, but I do have to take a call in a second. Let me. Is there anybody else going to come up to help read?
No, I can go ahead and finish. I know you're busy. Um, I appreciate your time. Yeah, she got another phone call. All right, yeah, I'm getting tired. Mm, it's a lot of reading, y'all. It's only perspective and myself, grand jurors. We're the ones that's reading. Can I hit the like button, please? Guys, guys, have any questions? All right, let me read this part. Restitution is the concept that after someone is found guilty, that the victim have a right to be made whole to whatever damages that have been they have suffered. And so what you're talking about, money that he has is something that will likely be taken up in the restitution context in addition to forfeiture. It's just we have a multiple tool to get money from defendant that are related to the offense and to make the victim whole. So I can assure you that our IRS agent who is on the case, this is his goal is to follow the money and to track it all. And he has been working really hard on that because we do think it's very important to make sure that there are assets available for the defendant should he be found guilty at the restitution stage. Yes? All right. The grand jury asks. So, following up with that, so he gets royalty every time any of his stuff is played. Could be used for restitution? And Miss Cruz said that yes, that's being investigated as well. the juror says. How does forfeiture work with Winkler and at McDavid? So Winkler is not named in any of this. He is his partner. He has to have some knowledge. I mean, so I understand it said that he forfeit his piece of that. You know what does that government do? What does the government do with that? It is monetary, his piece of it, what that firm? And Miss Cruz says, so are you
Okay.
asking? Go ahead, Miss Crew. I'm at line 10, page 49.
So, are you asking if Winkler, what Winkler's rights are since he's
Right, yes. Basically, yes.
yeah. So, as you noted, we're only seeking the forfeiture McDavid's interest in
Right.
Winkler and McDavid. And so Winkler, we have not alleged has any criminal liability at all. And so Winkler has the right to keep his portion, his interest in the corporation. Okay. Okay. So the last portion here, I want to make sure you have enough time to deliberate. There were some minor line edits to the indictments. I just want to point out to you all in paragraph 5. The first one is, I'm sorry, count 5. Paragraph 4 is the first one. Paragraph 4, the edit to this paragraph here simply identifies the videos. Before it said multiple videos. Now we included video 1, video 2, video 3, and video 4, just to be specific as to the videos we're talking about. So that's the edit there. Paragraph number 7E of the same count. This was just paragraph 7E and 11C. So they deal with the same topic, or they were just very minor rephrasing of how it was alleged there. So I think we already read this paragraph earlier, so I won't read it again. And then 11C, I have 11C related to the polygraph. There was some minor changes there. We had to change minor 2 to individual D, and we revised the language about the topics where of that polygraph examination. We didn't want to limit it to just to whether or not there were additional copies of the videotapes. So if you look at the last three phrases where it says including whether there are additional copies of the videotape, that means that there were other topics of the polygraph, not just whether there were additional copies. So the very last paragraph I will show you is 8D. This is related to payments to Mr. McDavid. We revised this paragraph to make it clear that the payments were not only for the initial cover up, but also for continuing to conceal and cover up the evidence. That's on the third line where it says to continue to conceal and cover up such evidence. We wanted to make clear that the payments were both back at the time when it happened and also later when he filed that lawsuit to continue to keep quiet about it. So that's all the evidence. I have a little note I wrote to myself down here about the exhibit 105.
Document displayed on the monitor screen for the grand jurors.
Miss Cruel, I'm sorry. Um, and what that means, oh gosh.
And what that means is that I was here last time. I believe you asked me about a particular photo that you wanted me to show you. We're going over actually Waller's testimony, and I didn't have the picture with me at the time, and she had identified number 105 as Abel Gabrielido, and somebody asked, I think it was you. I think somebody asked me if you had a picture of Mr. Garabilo. I wrote it down so I wouldn't forget. And so I just wanted to follow up on that. So this is Grand Jury Exhibit 105. And that's a photograph that Miss Waller identified as Abel Baldi. Document displayed on the monitor screen for grand jury. Okay, so I'm all done with my presentation. What I have here is a few copies of the proposed indictment. Superseding indictment, since I went through it over the screen, I didn't make copies for everyone. I just have a few extras here. So when I step out of the room, if you want to review those, you can do that. Oh, okay. The other thing I wanted to do, which we're required to do under the law, is present to you all the bank records that we have subpoenaed at the time of the indictment. So I can ask my paralegal to put it all on a disc for you, and we'll mark it the grand jury exhibit 119. And we have just a very general index here of all of the bank records that are on this. It's actually not a disk, it's a flash drive. So it's one of these fancy little flash drive because the volume of the records is humongous. So for each bank on there, there are numerous account numbers underneath each bank which have to do with Mr. Roberts Kelly's bank records, Mr. McDavid's, and Mr. Brown, and everyone else that you've heard, all of the corporation bank accounts, and all of that is all on that fancy little flash drive. So if you are inclined, it's right, you can review those bank records. I brought a laptop this time for you. If you are at all inclined to open up the laptop, you can put the flash drive in there and search through the bank records. It's totally up to you if you want to do that.
Which line are you?
I'm on 9. I'm a grand jury now. We need more than 5 minutes. Now 11. Now it's your turn.
Okay. Yeah. I will say that whenever we felt that there were irrelevant, or I'm sorry, relevant bank records, we pulled them out and marked them as exhibits. And you've seen them as we have gone over them. But we want to make available all of the bank records because they were all brought to you by the grand jury subpoena.
I was just wondering if you found the doctor that did. Do you know? Whoop, whoop.
It's still under investigation. That's one of the other reasons why we're keeping the investigation open. It's something that we're continuing to follow up on. Like I said, there's still a lot of unanswered questions, still a lot of things that we're investigating. So we're not ending our investigation by any means.
Do you don't think we'll see the polygraph examiner?
You might.
Okay.
We definitely have his records. We have talked to him. I think that there is a likelihood that you could see Jack Palladino. We are going through his records and determining whether or not he will come and sit for an interview. And if so, then we'll determine whether he will come and testify. So that's a possibility. And there are other individuals connected to that we have to follow up, that we are following up on. Okay, I'll step out.
Thank you. Miss Cruel exit. All
Okay.
right, it's been certified, and that's it, y'all. That's it.
It's crazy that Jack Palladino passed away during this, huh?
A couple of days after this, can you believe that?
Hmm.
Isn't that
Hmm.
interesting, y'all? Isn't that interesting? Interesting. Anybody have any questions? Anybody have any questions? You see how they played around with this stuff? No,
I said I apologize for my phone calls.
it's okay. You busy, girl. I appreciate you. What do y'all think? Crazy. Shake my head. You see what we mean? They played around with this. It's all about money, y'all. Y'all see what it is? It's all about money. You see how they brought the thing over to the grand jury about Aaliyah, and then they didn't put her in there, and this is crazy. Then Elisa Van Allen, her age, they realized that she wasn't 17, that she was lying, and they had to move her from being a victim to individual D because they felt her testimony was important, even though in the state she was found not credible. In fact, they were going to put charges on her, but they gave her immunity then and immunity now. Every single last liar got immunity. Inspector, you mighty quiet. What's your thought? What's your thought? All right, nobody have any thoughts? I'm about to get off now. And
You can't hear me?
I didn't hear anything you said.
Oh, I was just saying that I think that they exaggerated things to the grand jury to make them indict.
And that's why I agree with Daryl McDavid's attorney when he put in that law that request for him to give the money back, because it was frivolous, it was bad faith, and it was vindicious, whatever they said that word is. And they surely did cheat.
They did, and I mean, they were able to present the Aaliyah stuff to the grand jurors, but then not able to present it within the case. Like that in itself was
Dirty.
biased.
And then you
Yeah.
see, they said they couldn't bring her in. They could not bring Aaliyah in. That's why they brought the bribery, and they didn't do it here. They did it in New York so they could be part of the racketeering, because they didn't have
They
any
use
other.
it. They use it as a prejudice. Like it's like they use it to piss people off, but then
Because everybody
knew
kept
they
thinking
couldn't.
about Aaliyah. It's never been about Aaliyah.
Mm-hmm.
All right, I'm about to get off, guys, but it's been wonderful. Again, thanks to those who donated earlier. I gotta go back out there to work. All right, guys. I gotta
Bye.
go. Thank you again, Miss Cruel.
You're welcome.
All right, honey. Bye.
Bye bye.